Hello, everyone. Thank you for joining us. I'm Matt Valier. I'm the Executive Director of the Patients' Rights Action Fund. Welcome to our quarterly webinar series through which we hope to provide insights and understanding on the dangers, concerns, and realities of assisted suicide and euthanasia laws. For the benefit of some people with disabilities, I'm an early 40s man of color, dark wavy hair, clean shaven, olive complexion, wearing a purple and blue checked button-down shirt and a charcoal blazer in front of a white background. A bit of housekeeping for the webinar. We have an American Sign Language interpreter who's on their way for those who would benefit. And to turn on the closed captionings, you have to move your cursor more. Once you do that, you can see the Show Captions button. It's got a CC symbol. You can click that and it will turn them on. And then once it's on, you can adjust the settings if that's helpful to you. We're going to take questions, but via the Q&A function. Similarly, you have to move your cursor and click on that three-dot button. And once you click the Q&A, you have to type your question in. So please do so with your name, and if you're a journalist, your media outlet. And if for a specific panelist, please do indicate that. And for any further media requests, please contact Meg Tully at mtully@apcoworldwide.com. That's APCO worldwide.com. The session will be recorded and we'll share a link on our platforms afterwards. Panel, for anyone who's not speaking, please do keep your mic on mute. To set the stage a bit, our broken medical system is driven by inefficiency before people structure. People are not getting the care they deserve, and choices are often artificially limited by financially motivated players. Too often, medical professionals and society on the whole view life with a disability as less worth living, less worthy of care, and less worthy of our scarce medical resources and healthcare dollars. That is, better off dead. We reject that. No matter if the person has a disability that is truly terminal, as with ALS or some cancers, or disabilities that are non-terminal with treatment, like diabetes, or mental health disabilities. Although there are some cases of assisted suicide here in the States for anorexia, which is, as many know, a mental health disability, just north of the border in Canada, they're set to legalize, or implement, I should say, they've already legalized, assisted suicide and euthanasia for mental illness, broadly speaking, on March 17th, 2027. We have 4 Canadian experts here for you today who will provide an overview of where things stand, how we got here, and what they and our Canadian allies are doing to fight it. As many of you know, I often moderate these discussions, but this time we've asked our friend and champion in this fight, Amanda Achtman, to lead the conversation. Amanda is a native of Calgary, Alberta. She's the founder of Dying to Meet You, a project of cultural renewal to prevent euthanasia and encourage hope. She's a worldwide leader in the opposition to assisted suicide laws. Amanda, thank you so much for lending your expertise to this important conversation, and thanks to all the panelists who will introduce themselves once Amanda sets the stage. Amanda, please take it away.
Thank you so much, Matt, and thank you to all of you for joining us. We understand that this is a call with a lot of advocates who are at the forefront of pushing back against assisted suicide, and so it's a joy, it's very meaningful for all of us to be in conversation with you. I am Canadian, I'm in my mid-30s, I have curly hair, glasses, and I'm wearing a blue jacket. And here I am with my friends and fellow Canadians. We are going to share with you about this expansion of euthanasia on the basis of mental illness. But before, to give a very quick sketch of the context, I would like to begin by saying that in 2016, Canada legalized euthanasia nationwide. This is a federal law. It was an amendment to the criminal code, and this beginning led to a further expansion, which we will get into on the grounds of equality. So initially, euthanasia was for those with a grievous and irremediable medical condition whose deaths were reasonably foreseeable, but on the grounds of equality, fewer than 5 years later and before the statutory review, euthanasia was then being expanded on the basis of disability and mental illness. And in 2021, Bill C-7 passing this expansion did pass. And so as of March 17th, 2021, euthanasia was expanded on the basis of disability and mental illness. However, as Matt alluded to, the implementation of euthanasia where mental illness is the sole underlying condition was delayed. Initially, it was delayed by a sunset clause for 2 years, and then it was delayed at the 11th hour before its implementation, and it has since been delayed again on the grounds of readiness. The question has always been, are we ready to allow euthanasia for those whose sole underlying condition is a mental illness, rather than is it right to do such a thing? And so, a brief note on the distinct vocabulary. You may find us alternating between the terms. In the US, assisted suicide is where the doctor or nurse, the doctor prescribes the lethal medication. In Canada, the doctor or nurse administers the lethal injection in almost every single case. In 100% of the cases for 2024, all 16,499 people who went through with medical assistance in dying did have that direct provision. Technical distinction between assisted suicide and euthanasia, though we sometimes use these terms interchangeably. And of course, an umbrella term or made to either that assisted suicide or euthanasia. So that's a brief note on the use of terms, and that we may alternate and even bring in the term psychiatric euthanasia to describe this euthanasia for those for whom a mental illness is the sole condition. So that is a very quick sketch of how we got here, but we're going to go deeper into the legal scenario and into how this is touching people concretely and practically with our three tremendous guests who have been testifying before parliamentary committees, who are leaders in this conversation really worldwide as Canada stands as a cautionary tale. So at this point, I'd like to begin with Isabel. Isabel Grant, if you could please introduce yourself, and each of you, please share with us what brings you to these issues and to these questions, both professionally but also personally. Over to you.
Thanks, Amanda. I'm a law professor at the University of British Columbia. My work has primarily been on violence against women, and I've done a lot of work on violence against women with disabilities. And through that work, I became involved in a large national disability organization in Canada, and I chair the Strategic Litigation Committee for that organization, which is one of the only organizations that actually gets involved in court cases as an intervener. And we are currently challenging medical assistance in dying for people who are not at the end of their lives in the Ontario courts. So it's largely through my work with Inclusion Canada that I got involved in this issue, and most of my work has focused on what we call Track 2 in Canada, which refers to people accessing euthanasia who are not anywhere close to death necessarily. And it's really through that work and through, I see this as a form of violence against people with disabilities, and it's through that lens that I have been involved in this issue.
Thank you. Trudo.
Yes, so my name is Trudo Lemmens. I'm a white man of 60s with a short gray hair, trimmed beard, wearing a gray, black spickled shirt. I have two cochlear implant microphones on my head, and the background to my speaking is a disorderly office of a law professor. So I'm a law professor, have been teaching in health and bioethics at the University of Toronto for more than 30 years. I worked on legal and ethical issues and end of life for many years, and particularly before Canada legalized euthanasia and assisted suicide, I was already studying the developments in Belgium and the Netherlands because I'm originally from Belgium, and I could easily read the documents, the reports that were coming out of Belgium and Netherlands. My mother tongue is Dutch. So when Canada legalized euthanasia and assisted suicide, I thought that as an academic, I could contribute to the discussions that we were having because the Supreme Court had issued a judgment that said that some form of euthanasia-assisted suicide had to be permitted in Canada, had to be legalized. And I thought, well, we certainly should look at what has been happening in Belgium and Netherlands, where euthanasia has been legalized since 2002, and where I considered that there was a clear expansion, particularly after the first decade of the practice, with an aggressive expansion outside of the end-of-life context of people who were not remotely approaching their death. We saw, certainly since 2010, 12, an increase of people with severe mental illness receiving euthanasia-assisted suicide. And so I published on that. I published op-eds. I testified before the parliamentary committees. And I was flabbergasted how people who were pushing for a broad introduction of euthanasia-assisted suicide did not want to hear about that. They always presented it as if the data were clear, that there were no problems with the implementation of the practice. Speaking about this, writing about this meant that I was certainly also contacted by many people, including actually met Alicia that way, and joined disability organization expansion of MAID. I also accepted to the Ontario Chief Coroner's MAID Dead Review Committee, which I'll say something more about later, but it's basically a committee that is part of the practice, and I felt that at least from the inside, I wanted to understand what was happening. Why were people getting medical assistance and dying in Ontario, the largest province in the country? And this committee of the coroner's office reviews a selection of cases. So we would see cases where the coroner's office, which reviews all of the cases in Ontario, would feel that there were some common problems with cases that were of euthanasia cases that had happened, MAID cases that had happened. So the committee, and I'll stop there, but the committee has looked at common issues such as people receiving MAID for chronic illnesses, people receiving MAID struggling with dementia, troubling cases of people receiving MAID the same day that they requested it or the next day after they requested it, and a couple of other key issues that we addressed on that committee level. And so overall, I would say my concerns, I no longer really speak so much about Belgium and Netherlands anymore, because I think Canada has bypassed Belgium and Netherlands and has become the country with, in my view, most troubling developments that are a direct threat to persons with disabilities and persons with chronic illness in general who may be fast-tracked to receive euthanasia or assisted suicide.
Thank you. And now over to you, Alicia.
Thanks, Amanda. I am a Caucasian woman in my early 40s. I have wavy blonde hair and blue eyes and wearing a black shirt with a white background. And I came to this issue when my mother chose to end her life through medical assistance in dying in October of 2021. Prior to her death, I had no idea what the term medical assistance that assisted suicide in Canada was reserved who were terminally ill. My mother was in the middle of a mental health crisis. At the time of her passing, my sister and I had attempted to stop her MAID provision, and we were successful in getting a warrant for her arrest under the Mental Health Act. And unfortunately, hours after being released from a psychiatric unit, she was euthanized. My family has since gone on to launch the first and only police investigation in Canada against medical assistance in dying death. However, the health authorities have prevented our family and the police from investigating further by refusing to release her health records. I have since spoken internationally in the United Kingdom, where they are considering expansion for terminally ill adults, which I could talk forever about that as well, their flawed system, and most recently in the Canadian Parliament, again, with a committee that Trudeau was mentioning. So that is how I came to be a part of this issue, and really excited to be here with you all today.
Thank you.
Amanda, I'm just going to interject because I
Please.
didn't describe myself, so apologies for that. This is Isabel speaking. I am also a Caucasian woman in my 60s, short brown hair, glasses, um, and have a background of the law school library where I work.
Thank you. And speaking of law, Isabel, I'd like to come to you first with a little bit about how we got here legally and the initial criteria by which euthanasia was ushered in through the courts. Could you give us a quick sketch about where topics specifically that may pertain to Americans, topics of discrimination and equality, come into the big court cases that led to Canada's euthanasia regime?
That's a lot, Amanda, to do quickly. I think, as you said at the outset, we started on this path through our Supreme Court, the equivalent of the United States Supreme Court, holding that there had to be some room for physicians to assist people ending their lives. And they did that in the context of the right to life, that the right to life also protected people from forcing people to take their own lives prematurely because they wouldn't be capable of doing so later. The court did not address equality. The court did not address discrimination. And the court left a lot of room for Parliament, to our government, to decide what the contours of euthanasia would be. After that, we had one court in Quebec that expanded that further. But essentially, when this was first introduced in Canada, it was only for people who had a grievous and irremediable medical condition. And that included the requirement that people have a reasonably foreseeable natural death. So that's where we started in Canada, that medical assistance in dying was for people whose death was reasonably foreseeable. That was a very vague definition, along with there had to be a grievous, a serious and incurable illness, disease, or disability. There had to be an advanced state of irreversible decline in capability, and there had to be suffering that was seen as intolerable to the individual experiencing it, that couldn't be remediated through means that were acceptable to them. And then it was the courts again who got involved and said, no, wait, we can't limit this to people who have a reasonably foreseeable death, because that would be discriminatory against all the people with disabilities who aren't at the end of their lives but want to die. And that court, which was a lower court, didn't really address, well, wait a minute, isn't it discriminatory against everybody who doesn't want to die? It's not just people with disabilities. But it was very much premised on the idea that only people with disabilities would ever want to end their lives, that that's the only possible group that would want to end their lives. So we haven't really had a robust analysis of equality, which is why the organization I work with is going to be arguing in court that in fact allowing this for people with disabilities is discriminatory against them, because other Canadians who are suffering intolerably are entitled to suicide prevention and supports, whereas people with disabilities may be offered death instead of suicide prevention. So we will be arguing that that is in fact discriminatory against people with disabilities.
Thank you for that explanation and for all that you're doing on that front. Trudo, this has been called Track 2. The expansion of euthanasia on the basis of disability is formally and within government known as Track 2. And so what can you say about the rationale by which euthanasia was expanded beyond the reasonably foreseeable death criterion to persons living with disabilities? And how does that affect your research on law, vulnerability, capacity, these kinds of themes?
Yes, so the rationale is obviously, and this is always what is emphasized by people who have defended this, is that there are two people in Quebec who are persons with disabilities who asked for access to medical assistance in dying. They were deemed not to be eligible for the Track 1 made a route which was for people whose death was reasonably foreseeable. And so they said, we want to have access to our debt. What is interesting is that many people have commented actually that at one point in their life, if their situation changed, they would have had access to medical assistance in dying. But the court bought the idea and emphasized in its judgment that the suffering of these two persons was so significant that they should have immediate access to support in. What's interesting is that neither of them actually, if you read the description in the judgment, it sounds, or the way in which the judge talks about disability is very much as that these two persons were having such a horrible life that they actually had to have immediately access to medical assistance in dying. But when the judgment came out, they didn't immediately opt for it. Actually, one of the more than a year later, the other person, Jean Truchon, is actually a tragic case because it exemplifies the concern that many of us have with this form of state-organized ending of life on the basis of disability. He asked for MAID when COVID started, and when he was concerned actually about total isolation, that he would live in a long-term care home and he would no longer have access to family members who could visit him. So it's an example of how circumstances, how context have a huge impact on the suffering of persons with chronic illness and with disabilities. We see, since the practice has been expanded, also in the statistics by Health Canada, statistics that are gathered on the basis of self-declared declarations by physicians who have interviewed, assessed these patients for medical assistance in dying, and who then write on a form which is sent to the government the reasons why people consider that their suffering is intolerable. If you look at the reasons why people who have received MAID say that their suffering is intolerable, it are often socioeconomic factors. It often involves loneliness. So certainly in the context of track 2, more than 50% of people say that they suffer from loneliness and isolation. More than 50% of the persons who receive MAID in Canada say that they feel that they're a burden to others, to their loved ones, or to the healthcare system. So there are many factors that raise concern, raise red flags about how socioeconomic and contextual factors determine and influence people at requesting MAID, and also internalizing the suffering that is being said to be a reason for asking for medical assistance in dying. So as a member of the Ontario MAID Debt Review Committee, we have reviewed some of these cases, and we see a lot of cases, or we have received several cases where it's clear that there are intersecting components of mental illness and physical disability that lead people to request medical assistance and die.
Thank you. Alicia, I want to come to you for a concrete application of that last point, because sometimes we tend to attempt a clear categorization or a clear differentiation between physical illness or mental illness or end of life or the continuum of life. And in daily life, there's a lot of blurring of these categories and there's a lot of intersecting. So could you share a little bit in your own family story of how these hard and fast distinctions between physical and mental illness are not very accurate to the reality in family life and in daily life?
Yeah, absolutely. As I mentioned in my introduction, prior to my mom's passing, I didn't even know of the term that we use in Canada, medical assistance in dying. And it was through the police investigation and actually through the investigative work that I have done over the past 3 years, writing a book that's coming out this August, is really the ambiguity of the law and how that can really, any any assessor who wants to approve their patient, there's so many loopholes for them to be able to do this. So although in Canada, psychiatric euthanasia is not legal yet, having a mental illness doesn't currently exclude you from accessing it as long as you have a physical condition. And one of the things that Matt touched on in his opening was anorexia and eating disorders. My mom had a lifelong pattern of disordered eating, and she suffered a minor car accident in 2020, weeks before the COVID lockdown. And what I now understand through the interviews and the research and access to the medical records I do have is that my mom was severely restricting her diet. And because she was frail, and because our law doesn't require that a patient actually has any for my mom, eating would have been for her weight loss, and she was unwilling to do that, and therefore her death was reasonably foreseeable because she refused to eat. And so you can see how these ambiguous terms in the legislation can create massive chasms for people to slip through.
Yeah, thank you for illustrating that. It's such an important point that we already illness. It's simply that mental illness as a sole criterion discussion and before the parliamentary committee right now. And you've all been testifying before this committee. I wonder, would any of you like to share an experience about your testimony before the committee and where you think the discussion is going nationally? Because the review that committee devises will be quite decisive for whether or not this goes forward.
Yeah, I'll volunteer just because I testified with a colleague on how if we allow medical assistance in dying for people with mental illness, it's going to be overwhelmingly women who die from it. That's what we've seen internationally. We've seen that with track 2, it's roughly sort of 58% women, but in Belgium and the Netherlands, it's as high as 70% women when you talk about psychiatric euthanasia. The committee was totally disinterested in everything we had to say and didn't really follow up on any of it, just didn't care that that women who have a history of violence against them, women who have a history of sexual trauma, women who have experienced other forms of sexism throughout their lives would be overwhelmingly impacted by this law. The committee really didn't care. This committee comes across as a bunch of people who have made up their minds. Some of them have made up their minds in ways that we agree with. Some of them have made up their minds in ways that we do not agree with. But it's clear that they have all, as individuals, made up their minds. And when they ask questions to confirm their opinions rather than to seek knowledge or new information that might help them learn about this. I think it's important to mention that it looks like this committee is going to recommend a further delay of some kind. We don't know the details, but in response to that, an advocacy organization has brought more litigation in which a woman with a long history of bipolar disorder is seeking an emergency application for MAID. And I think those of us who are following that case think this is really an attempt to do an end run around the parliamentary process, because I think the politicians would like nothing better than to have a court tell them what to do on this so they don't have to take ownership and responsibility for it. So we have a woman who's arguing in court that it's an emergency for her to be given euthanasia and that it has to happen very quickly. And so that's also lingering in the background, and the media have really picked up on this case, doing a lot of interviews with this woman and really foregrounding her story instead of foregrounding the stories of people with mental illness who are doing their best to survive in a country that doesn't provide them with the supports they need to survive.
Thank you. I'd like to ask the others as well who testified if you could share an instance in which you came under a particular attack as you were testifying, which witnesses are not supposed to be attacked, but it happens sometimes. And also, what line of argumentation do you think is the most compelling and winsome in raising the alarm against this expansion? So either a point under which you were very scrutinized or some positive line of thinking that you think is catching the moral imagination of listeners.
I can jump in. During my testimony, I think Isabel clearly stated people on our side that really do seem that they made up their minds on this issue. And there were two particular individuals who really, I think, went to try to discredit my testimony. One of the senators actually said that he had read about my mother's death in the media and was trying to show that my mother was suffering, although that wasn't deny that my mom was suffering, but that it was allowed to happen so quickly in the midst of a mental health crisis. My family, my sister, I'll speak for my sister and I, we are not fundamentally opposed to assisted dying in the context of end of life. But what we came to testify back in 2022 to the same committee, the last time it was convened, was that we really did believe that if stronger safeguards were in place, that this could that we could responsibly expand. But what we have learned is that there is absolutely no possible way that we can responsibly do that. And the pro-expansion groups and senators and members of parliament don't want to hear that. The other point was that there is no oversight after the death. So beyond us not being able to have any legal means to stop the process, we had a provincial judge stop the initial provision because we had enough evidence to show that she was having a mental health crisis. And afterwards, even the police can't gain access to the records to determine whether or not her death was lawful. And I think it just really goes to show, when this other senator came essentially attacking my testimony, she was saying, well, this is an issue with the assessors. So the assessors are ready to move forward. This is an issue with the legal system. And I'm like, is this responsible then? It doesn't really matter what side we're coming at this, whether it's from the assessors. If the assessors aren't required to do better, there are going to be assessors and doctors that aren't going to do better. And we've seen this. There's some prolific doctors in Canada who will diagnose someone with chronic fatigue and kill them for it. So it's highly concerning.
Thank
So
you very much. Yeah.
I can testify that it was as I've done in previous parliamentary committees. I testified before previous parliamentary committees, particularly in the context of MAID. It has always been very difficult to reach people who are convinced that this is the thing that has to happen. So how there was an unwillingness to really engage evidence, and so I came with evidence. My particularly on a couple of issues, but one of the key messages that I had was that the current MAID practice, in line with what Alicia is mentioning, that the current MAID practice, which already includes to some degree mental illness, is a canary in the coal mine, and is really sending the message that there are problems with Canada's MAID practice, that there have been questionable approvals, often of ill-understood illnesses, because the idea, whatever position that you take, at least the law says that there has to be an irremediable medical condition and an advanced state of decline of capability. So I think the law reflected at least this idea that it's really kind of a last resort, but the reality is that it's being provided for illnesses that are not well understood, where mental illness is often seemingly a motivating factor, but it's not recognized, where euthanasia MAID is provided despite suicidality and unaddressed that some maid providers do the most minimal capacity as key safeguards. Well, we see, and these are things that I've seen when I was a member of the Maid Dead Review Committee in Ontario, we see at times incredibly minimalistic capacity assessments leading to a person's approval and then lethal injection, often in a very short period of time, sometimes in the same day or the next day. We see a fast tracking of MAID, even when people have just a chronic illness, because the guidelines of semi-professional but quite activist MAID organizations are such that they recommend or that they give guidance as to how you can turn somebody who has a chronic illness who is not approaching their death into a case of somebody who is approaching their death and thereby can have faster access to MAID. So overall, my message was there is an emphasis in Canada's MAID euthanasia practice and policy on access, not on protection against premature death. And there was really a pushback against that. You know, people start questioning. I mean, data are difficult to come by. It's very, very difficult to have strong data, but at least there is a strong beginning of evidence in, for example, the coroner reports, which are based on reported cases where it's the MAID providers and assessors who have themselves described certain cases. And these have been reported in a narrative format. One other thing I would want to say is that was not in my session, but one thing that I found was the showcased the incredible ideological commitment of some members on the committee, particularly some senators. At one point, we had a psychiatrist testifying about suicide prevention in Canada and testifying about her role as the director of a suicide prevention program, which includes a 988 actually suicide prevention hotline. And the senator asked, is your service providing objective and neutral information about MAID to callers? I thought, how many reasonable people, or what kind of reasonable person could think this is a normal question to ask, that a suicide prevention hotline should start telling people, oh, you're calling because you're concerned about ending your life. Well, we have another option, and it's euthanasia. It doesn't make sense to me. I found it deeply, deeply concerning. And then what we've then seen is that in the media, the same senator complains about bias and predetermination of the committee. And so you have here a senator who complains about predetermination of the committee because he sees that the committee may be recommending against introduction of MAID for mental illness, but he doesn't even recognize the clear overlap between suicide and euthanasia or medical assistance in dying. It has been very disturbing, actually, as somebody who has been working in this field for quite some time, to hear that, because I think it exemplifies the normalization of a lethal injection by physician as some kind of inherently beneficial medical practice that has to be offered on an equal footing as any other form of care.
Thank you for that. And it's
if I can just add to that.
Yes,
so we have a couple in our litigation, we have a couple of individual plaintiffs who, both of whom have been offered euthanasia when they sought support for a psychiatric crisis. One called a suicide hotline and was offered euthanasia. Another went to an emergency clinic having a history of suicidality and was told that medical assistance in dying would be a much sort of more peaceful option than potentially committing suicide. And these two plaintiffs talk about how much harm that did to them. I think we only talk about people who are actually wanting euthanasia, but we don't think about other people with disabilities and the harm that this law is causing them.
Yeah, thank you for that. And I was just going to reinforce this point that the laws seem really designed to protect doctors and nurses because the criminal code exemption from being charged for charged. Creating an exception to the criminal code offense of homicide for doctors and nurses within the circumstance of MAID. I want to encourage our listeners to begin submitting your questions. Some already have, but feel free now to begin using the Q&A function to add your question. At committee level, that there has been a thorough insistence on the inability to predict irremediability. This has been the consensus among all the chairs of psychiatry across the country, that you cannot predict definitively which mental illness could never improve, where a person could never get better. And so that point is being received to some extent. And we also have another basis for hope in recent days, in recent months, with Alberta, my home province. I'm actually in Calgary today. Alberta just introduced and passed the Safeguards Act, as they title it, that would bring in some restrictions and limit euthanasia in Alberta. This marks the first positive legislation in a decade of Canada's euthanasia regime. And what Alberta is doing is essentially eliminating that track too, the disability track, and is stipulating that those who are opting for euthanasia have to be within 12 months or less of life. That has to be the prognosis, whereas there's no timeline at the federal level. So these are incremental measures, and Alberta is also preemptively banning euthanasia for mental illness as the sole underlying condition, proactively banning the expansion of euthanasia to children and to adults who are unable to make their own healthcare decisions. And so, mindful of the expansionist tendencies at the federal level, Alberta is exercising its provincial sovereignty, if I dare use the term, and saying we don't have to follow the status quo. There can be a different way. And so I think that is hopeful because it demonstrates some form of leadership. Would any of you like to comment on Alberta's Bill 18?
Maybe I'll just say that we're expecting that bill to end up in court as well, that the Dying with Dignity, which is this organization that has pushed euthanasia from the outset, is likely to be challenging that, saying that that bill violates the rights of people who want access to euthanasia. So I think that story is not over yet.
Absolutely. And even the Alberta Medical Association, in conducting a survey of its physician members, used the language of access throughout the entire survey, which is a problem, that everything was framed as a matter of access. And will this bill impede access? Well, yes, of course, that's the point. But it was framed very negatively and detrimentally, which seems to prejudice it one way quite obviously. So there's that. And of course, there are other court challenges against MAID-free spaces. There's a hospital right now that will not euthanize patients on site. And so Dying with Dignity, the Canadian equivalent of Compassion and Choices, is engaged in a lawsuit because there's this going after any site that does not offer euthanasia directly on site. This is being framed by the euthanasia proponents as institutional obstruction of access. And for patients, especially patients living with disabilities, this is a matter of lacking access to any MAID-free space, if MAID must be offered anywhere. So you touched a little bit, Isabel, on the toll that it has, especially on people with disabilities, about how ubiquitously offered it is. Would anyone else like to elaborate the toll that it's having on individuals? Euthanasia is not the last resort, but is sometimes the first suggestion.
I think I can just jump in. Many people don't actually know that this is happening. And so for a family advocate, we're regularly gaslit within the system, being told that this isn't true, that this isn't happening, you're exaggerating. And so I think there's this huge lack of education on what's actually happening when people do find out that, in fact, it's a doctor's responsibility, that if they believe you qualify for medical assistance in dying, that they actually bring it up to you. And so you can see how coercive that might be. I have spoken in parliamentary press conferences alongside family members whose loved one was in the hospital for something unrelated. A doctor, it turns out, falsely diagnosed them with a condition. Their loved one was in a vulnerable state, chose to die, and then found out afterwards they didn't have the condition that the doctor said they did, which ultimately, was the deciding factor for them to end their life. And there's no recourse on this. So um, I'm not sure education about what's happening.
To that point, I have a question from a participant who says, my Canadian friend says this is not true, and her family that lives there says the same. What can be done to raise awareness among the general Canadian population? What do you think about the disbelief with which you are yourself sometimes met?
Yeah, I mean, there are enough stories in the media to point this out. And again, we're gaslit, we're called outliers, and these are very rare, circumstances. But I think encouraging people to talk about their experiences and what is happening is the only way that we're going to shift societal perception. I'm sure Trudeau and Isabel have other points, but from a family's perspective, that's what I see.
So there are two interesting, there are actually more than two, but there are two interesting studies that show, one study from the NIH that canvassed quite a lot of people outside of Quebec, so in all the Anglophone Canada, and then there are two studies, at least two studies from within Quebec that looked at what people understand about Canada's MAID regime, and it's clear that MAID has become quite popular, quite supported in Canadian society in general when it comes to end-of-life situations, people who are approaching their death, that many people actually don't fully realize that it's so broadly available, that it actually is offered for people who with chronic conditions. And if certain scenarios are tested, for example, if you test with people, the scenario should MAID be available for people when there are other treatment options that will very likely relieve their suffering. Most people, or more people will say no than people will say yes. But still, that's not reflected in the media coverage. The media coverage is overly positive. There is a certain shift going on because we've seen a more critical reflections on some of the practices. So I think that's a good sign. I would say something also about your concern about harm. I think there is a much more subtle harm that I have observed and that I increasingly fear will be very, very hard to fight, which is the insidious harm of how people's norms have changed towards people who are elderly, ill or disabled, people who are certainly, so for example, certainly persons with dementia. And I've encountered that in conversations with people who start talking in a way about disability and about elderly and about the meaning of still being alive in a situation of extreme frailty or simply general frailty, where people start openly now saying in Canada in a way that so-and-so aunt or a grandmother, this and that, it's no longer worth it. We try talking here about my immediate environment, where people would say, you ask, how is your mother doing? And a person would say, oh, she's so and so, and she increasingly she starts having cognitive decline, and she now will fall and will break a hip, she'll end up in the hospital, and that will be it. We've been trying to obtain MAID for her, and it's like, you have been trying to obtain MAID for her. So it's the kind of the language, the insidious way in which people talk about what it means And we have to be really concerned about how that impacts on people, how people think about themselves. If you're elderly and you have some cognitive issues, and you see all people in your situation being told or opting for medical assistance and dying, or making advance requests, which are now legalized in Quebec but not in the rest of the country, it impacts on how people perceive themselves. So I think that kind of insidious impact on how people perceive themselves when they're elderly or sick is very, very concerning.
Thank you for that point. It's so important because just fitting the criteria itself is dehumanizing, being sent the message that there's a social category of human beings that could be sent this message that you could just not be here. So thank you for that. Briefly on advance requests, which you mentioned, that is essentially a policy of death for dementia, where you can request euthanasia ahead of time upon a diagnosis of dementia to be done at a later date that you specify according to some subjective criteria. That is illegal federally, and Quebec is breaking the law by doing this and is yet not prosecuted. And more than 2,000 people have made these advance requests. So that is a major, to our advocates listening, this is a major warning to watch for, the increasing dehumanization of persons with dementia. I know Isabel wanted to jump in, and I see Matt's looking to as well.
I've had lots of chances. Matt, why don't you go ahead?
There we go. Amanda, you said something that I found compelling, particularly because as we think through how we in the US are going to approach our opposition to these laws and pushing back, this defense simply is not enough. Inclusion Canada has filed their charter challenge against Track 2. You said that it's the very categorization of a person as eligible. We've made the argument in the lawsuits that we've filed against particular states that have legalized assisted suicide that is the primary harm done. That the discrimination itself is the first harm done. As obviously the other harm done is being put at risk of deadly harm, and then of course dying at the hands of the state and medicine. But my question is really ordered to the kind of thought process on our collective legal offense, whether it's here in the States and Canada against Track 2. Does Canadian law see disability in the same way as, say, the Americans with Disabilities Act? So under the ADA, everyone who qualifies for lethal drugs under American assisted suicide laws, which require that 6-month or less prognosis, all of those prognoses underlie a condition. And all of those conditions, whether it's cancer or ALS, it can be truly terminal, like the person is unequivocally going to die, say, in the next 4 weeks or something. It's not all conditions that without treatment you would become terminal, right? So there are those too, which are maybe a little more heinous. But everyone is put in this category of people who do not get suicide prevention care and services. And so in light of that, I guess it's a bit of a twofold question. Is everyone who qualifies even under Track 1 considered a person with disabilities under Canadian law? And if so, were your Track 2 challenge to be successful, does it basically automatically undo Track 1 too?
Isabel.
Maybe I'll take that one. Yeah, that's such a good question, because I think the answer to your second question is yes. Everybody who access is made is a person with a disability, but we do not recognize that in a widespread way. People who have cancer don't think of themselves as people with disabilities. They think of themselves as people who are ill, but that disability includes that. So I think yes, I think that is a barrier to our challenge, is that the court will say, well, wait a minute, you're saying everybody's disabled. Isn't that true of track 1 too? Yes, it is. And we think track 1 is problematic as well. But because our highest court has said that you have to, in that way. And I think if we could persuade a court that only people with disabilities get this and everybody who gets it is disabled, we would have a better chance of winning, but also we'd be up against that barrier that you have identified.
In their ruling on your case, undo the Carter decision?
No, we're going to a lower court. I mean, theoretically they could, because that's how we got to here, is that a judge decided that an earlier decision could be rethought and we could open the door to MAID. But no, and we're not asking them to do that because we feel that will just put the court off. But I think that's a huge barrier it's a huge problem with our litigation, that everything we're saying about track 2 really applies to track 1 as well. But hopefully the court won't be smart enough to ask the question you asked.
Well, maybe they don't need to at least rule on track 2 and provide at least some protections for Canadians with only non-terminal disabilities, I guess I would call them. I mean, it's maybe a distinction without a difference, but
I mean, it's interesting because the government that collects data asks people who are receiving MAID, are you disabled? And not 100% say yes, although many more say yes for track 2 than for track 1. Most people who get track 1 do not label themselves as disabled for reasons that I said, like, I have an illness, I'm not disabled, because of all the stigma around labeling yourself as disabled. So we have this distorted idea that only a small number of track 1 people are actually disabled, and maybe 60% of track 2 are disabled, which is utterly false. If you look at the definition of disability under the human rights, the UN Convention on the Rights of Persons with Disabilities, if you look at Canada's Accessible Canada Act, if you look at all the human rights acts, everybody who gets MAID qualifies as a person with a disability.
Thank you, Isabel. Amanda, I'll turn it to you.
Yeah, thank you so much for that. That's so important. And to connect to Trudeau's points earlier, this connects with how people with disabilities are regarded by others and treating, like, how does a person with a disability treat oneself, and what is the societal impression too? Because if people get the impression that they would rather die than live with a disability and are using MAID to preempt a life with disability, that certainly has a social consequence with a ripple effect across the entire culture. We are coming to the end of our time, but I want to give each panelist a moment to very briefly, in a minute or less, what is your warning and message to our American friends and advocates in this space based on your own experience and reflection? So maybe start with Trudo.
Could you repeat it again?
Yes. What is your word of warning and your message to our American friends here who are advocating against assisted suicide based on all of your long-standing experience in this space?
Yes, so I'm increasingly worried about contagion, to use a context that in psychiatry obviously is about suicide contagion, the contagion effect of starting to cross that border, like starting to offer it in some circumstances. There is an incredible dynamic that has developed. There is a strong international organization to promote this as a form of medical care. And I think there has to be, you have to strongly push back against that and warn about the normalization of a state-organized ending of life, particularly resist, I would say, the medicalization of ending life as a form of therapy, I think is key. And really try to avoid that the medical profession is co-opted and is starting to fulfill a dual role in practice that some very ardent promoters will embrace, but that will inevitably expand.
Thanks. I'll come to Isabel and then I'll give the last word to Alicia.
Yeah, once you start to see death as a solution to suffering, you can't limit it. So you may think, some of us did, that it's okay to allow this for people right at the end of life. But if it's based on suffering, why would you deny it to children? Why would you deny it to people who can't consent? Why would you deny it to anybody with any kind of disability? So it's wrong to think this can be confined. Once you open the door, you're on an inevitable path to what Canada has done. So really resist at those early stages, because once you open that door, it becomes so much harder to resist.
Thank you, Alicia.
From my experience in the past almost 5 years, mom passed away, there's this real argument for autonomy. And I think what people fail to really consider is that if you don't actually have any choices for care, then your choice is not autonomous, that you are not making a decision based on having real options for treatment. And the argument is always framed back to end of life. Yes, but I have a family member who had cancer or had all of these conditions. What Isabel said is that once you open this door, you can't close it. And I really want people who are listening to this to talk to their family members and just ask them to have an open mind and curiosity about only believe in autonomy and when of what is really happening, that by some puts vulnerable people in at risk. And that's my kind of my message, is just encourage education, having real discussions about what's actually happening.
Thank you so much. And just before I turn it over to Matt, I want to offer, since there are some excellent questions to which we didn't come, maybe we can do a roundup by email. Some of them require more elaborate, thoughtful answers, and I'm sure I can offer our panelists to compose some very thoughtful, short paragraph long reflections in answer to your questions. And we can also provide some additional resources, links, contact information as you've requested. So we are attentive to that. We appreciate your engagement. And with that, I turn it over to Matt.
Amanda, Isabel, Trudeau, Alicia, thank you so much for providing both your personal experience, but also your expertise. And obviously, this fight's not over, and for you all, it's become something that's really driving your lives in a way. This is a fight for your lives and the lives of your fellow Canadians. But what you're doing there in Canada isn't simply for Canada only. As time goes on, I think Trudeau has mentioned in his final comments, this issue is being pushed internationally. It's an international conversation, and when things happen in one place, especially so close by as our neighbors are to the north, then it will and does impact us as well, and vice versa. And so I think that we, arm in arm, need to continue to fight. And there is hope in aspects like Alberta pushing back as a province, like the are doing, and like the elevation of personal stories and data and information, as you all have done in Parliament in these past few weeks very admirably, is the way that this stuff gets on the record. People just don't actually know. I think that that's what our challenge is here in the States, is that people aren't really paying that much of attention to it, but they're starting to ask questions, and they're asking questions because of the good work that you all have done in elevating the tragedies that have happened in Canada. And it makes people have second thoughts, and that is what changes the game on this issue. So thank you again, and thanks to all of our attendees and for staying a little bit over time. We're grateful for your time. Take care.